Could your employer really deny your hard-earned overtime pay just because your records weren't countersigned? Discover how one security guard's fight for his rightful wages reached the Supreme Court and revealed a shocking truth that every worker needs to know. Find out what happened in this gripping case. This is the 84th case out of the 160 cases decided by Associate Justice Mario Lopez, chairperson of the 2024 Philippine Bar Examinations. Hit that subscribe button and get notified about our latest content. Watch our videos to increase your chances to recall these doctrines and concepts. This is the case entitled Zonio v. First Quantum Leap Security Agency Incorporated, and Romulo Q. Par GR number 224944, May 5, 2021. Facts of the case: Reggie Orbista Zonio, was hired by First Quantum Leap Security Agency Incorporated, managed by Romulo Q. Par, on March 13, 2011, as a security guard. Zonio worked alternating 12-hour shifts, 7 days a week, for a monthly wage of 8,500.00. Monthly deductions of 60.00 pesos were made for a cash bond and miscellaneous fees. Zonio claimed he was not compensated for overtime work, holiday and rest day work, night shift differentials, service incentive leave, and 13th month pay. On April 21, 2014, Zonio and some colleagues were suspended for allegedly sleeping on duty. The suspension, lasting from April 21 to May 20, 2014, was implemented without a formal investigation. After serving the suspension, Zonio was not reinstated, prompting him to file a complaint for illegal suspension, underpayment, non-payment of various monetary benefits, and moral and exemplary damages, along with attorney's fees. The respondents justified the suspension with photographs of Zonio sleeping at his post and claimed he was oriented about his salary and benefits, to which he agreed. They argued that minimum wage laws do not apply to private security guards like Zonio and sought damages for the company's tarnished reputation due to the complaint.
The respondents justified the suspension with photographs of Zonio sleeping at his post and claimed he was oriented about his salary and benefits, to which he agreed. They argued that minimum wage laws do not apply to private security guards like Zonio and sought damages for the company's tarnished reputation due to the complaint. Decisions of the lower courts. The labor arbiter ruled that Zonio's suspension was valid and denied his claims for overtime and holiday pay, holiday and rest day premiums, and night shift differentials due to lack of substantiation. However, the arbiter awarded salary differentials, 13th month pay, monetized service incentive leave, and a refund of the cash bond and miscellaneous fees. Zonio appealed to the National Labor Relations Commission, NLRC, which modified the labor arbiter's decision, granting his claims for overtime, holiday, and rest day premiums, and night shift differentials. The Court of Appeals, CA, partially granted the respondent's petition, deleting the award for overtime pay, holiday and rest day premiums, and night shift differentials, citing lack of concrete proof. Primary issue in the Supreme Court: did the CA err in deleting the award of overtime pay, holiday and rest day premiums, and night shift differentials due to lack of concrete proof? Supreme Court decision: the Supreme Court partly granted Zonio's petition. It ruled that a motion for reconsideration is not required for filing a petition for review on certiorari under Rule 45. The court emphasized that administrative bodies' factual findings are given great respect and even finality, but in this case, the conflicting findings between the labor arbiter, NLRC, and CA justified a review.
Dispositive portion: the petition is partly granted. The decision of the Court of Appeals is modified, entitling Zonio to overtime pay and night shift differentials. The case is remanded to the labor arbiter for computation of Zonio's monetary award. which shall earn legal interest of 6% per annum from the finality of this resolution until full payment. Important doctrines. 1. Prima facie evidence. Logbook entries by employees, even if not countersigned, can serve as prima facie evidence of overtime work unless effectively rebutted by the employer. Explanation. This doctrine underscores that initial evidence, if unchallenged, can establish a claim. 2. Burden of proof. For claims related to salary differential, service incentive leave, holiday pay, and 13th month pay, the burden of proof rests on the employer. For overtime and premium pays, the burden shifts to the employee. Explanation. It clarifies who must present evidence to support their claims depending on the type of compensation. 3. Rule 45 petition. Filing a motion for reconsideration is not required before filing a petition for review on certiorari under Rule 45. Explanation. This simplifies the process for employees seeking justice at higher courts. For conflict of findings. When administrative bodies have conflicting findings, the Supreme Court is justified in reviewing the factual issues. Explanation. It allows for a higher level of scrutiny when lower courts and commissions disagree. Ensuring fair judgment. Subscribe to our channel for more legal insights that could save your life someday.